Hi, my name is Weston Montrose. I'm certified by the State Bar of Arizona as a specialist in workers' compensation. I'm one of the founding members of Arizona Injury Law Group. Please visit our website at www.arizonainjury.com. This video is intended to give you some information about a common defense to a workers' compensation claim called failure to forthwith report. When an accident occurs, the law states that the employee shall forthwith report the accident and the injury resulting therefrom to the employer. The reason is so that your employer has a fair chance to investigate the circumstances of the accident and make arrangements for prompt medical care. The law is Arizona Revised Statute 23908E. I don't feel good. That's not good enough to tell your employer. In order to satisfy the duty to forthwith report, it's just not good enough to tell your employer that you don't feel good or that you need to see a doctor or that you can't come to work because you have an injury. You need to clearly report that you're having a problem that may be related to your work activity or your work environment. Also, it's important to report to the correct person. A coworker or a subordinate is not good enough. You need to report to your direct supervisor, a foreman, your human resources department, a safety coordinator, or someone who's above you in the company's organizational chart. Remember, you can't just be in passing either. You need to make it clear that you believe your pain is related to work activity and then go see a doctor. There is a severe penalty for failing to forthwith report. The law says that if you fail to comply with the forthwith reporting requirement, the consequences are, quote, no compensation shall be paid for the injury claimed to have resulted from the accident, close quote. However, a judge can relieve the injured person from this harsh consequence if the circumstances of the failure on the part of the employee or his physician to report the accident or injury are such to have excused them. So Arizona Revised Statute 23908F talks about some excusable circumstances. Sometimes it's not always clear that an injury has occurred or that the injury has a relationship to work. For example, many labor-intensive workers, they experience sore muscles and joints on a daily basis, but they don't report an injury because those day-to-day aches go away quickly after a good night's sleep or the weekend, and they never require medical attention or miss any time from work because of it. But after that rest time, if it becomes apparent that the problem is significant and requires medical attention, it's time to report. There's a specific case where the court said an employee need not report every bruise or scrape to his employer. Rather, you have to report your injury only when, with the exercise of reasonable care, you should know that you've suffered a compensable injury. The judge can also excuse a delayed reporting if you can show that there was no prejudice to your employer. This means that the injury wasn't aggravated because of the employer's inability to provide early diagnostic and treatment, and also that they haven't been impaired in their ability to investigate and prepare their case. So here's the conclusion. As soon as you know that you've likely been injured or become ill in any part due to your work activity or your work environment, you should report that situation to your supervisor. This is critical to protect your right to get medical attention and compensation benefits if that problem causes you to miss time from work.